final matter this afternoon is number 58, People versus Wayne Henderson.
May it please the Court, Chris Blair-Kosler, Office of the Queens County District Attorney for Appellant. I'd like to request 2 minutes of rebuttal time, Judge.
2 minutes, sir?
Yes.
Yes, you may.
Thank you. Your Honors, this case is entirely unlike a case like People v. Oliveris, where the defense did nothing to investigate, prepare, and present the proper defense at trial. Quite the contrary, it's the polar opposite. What they did here is present, or investigate, present, and prepare 3 complementary defenses that worked in total harmony at trial, including a psychiatric defense. Now, to support that psychiatric defense, they've got probably one of the best witnesses that they could have gotten, Dr. Stephen Billick, who was a very experienced, educated, and accomplished psychiatrist, and they got him to do what he needed to do to support this defense, which is...
How can you prepare that expert without informing the expert of the theory from the people?
Well, I mean, unlike in Pavone, where there was testimony about the audio recordings, both experts said they're important to one extent or another. I think the prosecution experts said that they're extremely important. The defense experts said that they're quite useful and important, even though he said, I don't need them for my opinion. It's kind of strange testimony. It seems a little bit contradictory. Here you don't have that testimony. And the other thing about and there's no evidence whatsoever that this is the type of stuff that a normal, ordinary, reasonable psychiatrist would need to rely on to formulate an opinion.
That wasn't
Counsel,
your
how do
argument.
you respond to the fact that if an attorney intentionally withholds information from the expert they've chosen to employ in assisting the defense, that strategy misleads not only the expert, but possibly the jury as well?
Well, I mean, the thing here is that there was nothing misleading that occurred, because if you look at the evidence about the wounds, the expert had a correct description of what the wounds were like. They were all over the body. The photos reveal
What
that.
about the snitching theory?
Well, again, that's a theory. The prosecution had their theory. The defense had many theories of how this happened. I don't think in order to give an honest presentation to the jury, you have to tell your expert about the people's theory of the case. You can prepare your own expert based upon your own theory of the case. And the jury hears that theory anyway, because it comes out at trial. So I don't think there was anything unethical going on here. And, in fact, what went on here was quite within the scope of what happened in Pavone. In fact,
straighten this out for me, then. I didn't see anything ethical in this thing. But the people made a big deal out of the very things you're saying, it was okay for them to do. I mean, I don't say you denigrated the defense, but in summation, the people went after this expert and his lack of knowledge of certain things and failure to disclose certain things. And it seemed to me it was an important part of your summation. And now you're arguing, but none of that. I mean, that's not bad. It's okay that you don't show them the pictures. It's okay that you don't do other things. And that is not what you told the jury.
well, I mean, when I say okay or not okay, this is all a matter of strategy, and we have very little on this record as to why they employed this particular strategy. For all we know on this record, there could have been 1, 2, 3, 10 experts before Dr. Billick. Maybe they didn't want to testify because of this motive theory, or because they saw the pictures, or because they saw the medical records. So if all that's true, why would they repeat this same mistake with Dr. Billick? Why would they disclose the same materials to him that precluded these other experts from testifying in their favor or offering an opinion?
Is that what happened here? They looked at 10 experts before this?
Well, I mean, we have very little information about what happened here because there hasn't been a 440. There's been no hearing. There's been no post-judgment expansion of the record. But I think it's a reasonable inference.
Aren't you just really saying that the fact that you use it for cross-examination doesn't mean that it's ineffective assistance of counsel in the first place?
Yeah, I mean, just because something comes out on cross doesn't automatically mean, oh, the attorney's ineffective. I mean, this is something that happens in every single case where a party puts on witnesses, whether a lay witness, whether an expert witness, it doesn't matter. No witness is bulletproof. Every witness is going to be cross-examined. Every witness is going to be impeached.
Sure, but isn't it one thing to have a witness who gets put under some very serious cross-examination and perhaps looks weak in the course of that, versus not giving information to the witness and preparing that witness so that the only result of that is going to be a cross-examination that's going to show that the witness's opinion should not be relied on. They're just not credible. They don't have all of the information. And as the people tried to show, and unfortunately this defense counsel made clear to the jury, it's because they the attorney chose not to give that information because it would mean there would be a very different opinion that's not favorable to the defendant.
I mean,
Aren't
just
those different things?
different in the sense of you should fully prepare the expert and give them everything. I mean, if it costs you that expert's testimony in the end, if there were other experts who refused to testify based upon
Doesn't that tell you
this
something
info,
about your potential defense?
well, these are the cards that they were dealt. I mean, this is what their client said. I blacked out. I didn't know what I was doing. I had no intent. They had to play the hand that they were dealt. And I think they played it in the best way possible.
Well, to that point, counsel, what about defense counsel's statement to the jury in summation that I didn't show this expert the photos because he probably that would change his testimony or change his diagnosis? What about that statement? We have that statement as some evidence or in the record
Right.
that counsel made a strategic choice not to provide this expert with all the information.
Right. I mean, maybe there were other ways to say that, and maybe anyone in this room would have elaborated on that a little bit more, but I think it's pretty clear what they meant, given their position on the photographs, the same position they took at trial. And they kept telling the jury and objecting at trial about the prejudicial impact of these photos, that they're inflammatory, don't let sympathy sway you. So I think the jury was able to read the comment in the context of the position they took regarding the photos and know what they meant. I don't really think that these two attorneys that put on this, very vigorous, very, zealous defense, that all of a sudden they're going to stand up in front of the jury and just torpedo their own case, and that's what the jurors are going to think, like, oh, they just admitted a fatal weakness to us. No.
So do you see this as one error or more than one error that the defendant is pointing to?
No, I mean, I think it all flows from the cross-examination. That's essentially what led to the reversal, the summation comments. Again, they all flow from the cross-examination. So it's really one error. And, it's just talking about the prosecutor's summation, because I don't think I answered your question. The prosecutor hit a lot of points. The fact that there were, other experts, two other experts, twice as many as the defense had, that said, this is social conduct disorder. This is just, has nothing to do with delusions, has nothing to do with blacking out and losing intent. The doctor's own test revealed that this defendant might have been faking his own symptoms. He mentioned this evidence that came out at trial about a drawing of a tree. Dr. Billick had the defendant draw a tree, and he tried to make it seem as if, the tree's falling down. The prosecutor was like, well, it's standing straight up. And he mentioned that and said, he's just trying to give him a pass. And he mentioned other evidence as well, the fact that there was no sign of injury or intoxication when the police came upon him shortly after the crime. He was basically sitting in his room playing video games with the co-defendant, which is a kind of a strange way to spend your time after you nearly kill your best friend in like a blackout state. He lied to the police. But what all this shows, basically, is that, again, the defense was dealt a bad hand. They had to make the most of it. And it wasn't just an adequate defense, it was the best defense. And I see my time is up.
Thank you, sir. Counsel?
Good afternoon. Layla Hull from Appellate Advocates for the Respondent. The Appellate Division...
Let me ask you a little bit, a question slightly different from what the people are arguing about. This is the hand that's dealt to the defendant and to defense counsel, and they're making the best of it. Didn't defense counsel come up with a particular view of the evidence, right? One of these defenses, this is what occurred. The victim is lying. CP is not to be trusted, right? So isn't that really the presentation that the defense counsel, or that's the defense that the defense counsel is trying to present to the jury? And so in that line, that's how they prepared their expert. The defendant has this story. And if this is the story, I prep my expert for that story because that's what I'm presenting to the jury, versus the people have a whole different story that occurred. The victim has their own story. We say that's not the story. This is the story, and the expert is testifying based on that story.
I think I would disagree slightly. To a certain extent, I understand what you're saying in this. The expert's testimony does credit Henderson's version of events. But for that to work, it would have to also play into the diminished capacity of the psychiatric defense. So there is to a certain extent a challenge to the complainant's version of events, but also even if the complainant's version of events is the jury can credit, it's about Henderson's point of view. What is he thinking? What is he feeling? What is he believing is happening? And given that this is a psychiatric defense, the jury didn't have to completely disregard the complainant's version in order to credit the psychiatric defense here.
So counsel, the jury rejected the defendant's defense of justification, essentially finding that that was not credible. So does that undermine the expert's opinion who relied on the defendant's version?
I think the two are interrelated. The justification defense always takes into account the state of the subjective, partly the subjective state of mind of the person claiming self-defense. If that, to a certain extent, the psychological condition of our defendant is part of that analysis. If the jury was, I would switch up the order, in other words. They didn't credit the diminished capacity defense, therefore they couldn't credit the justification defense, because the two were interrelated, at least as it was presented. This wasn't simply, they weren't mutually exclusive arguments. They were put together to a certain extent. And this actually goes back to the central point here. Dr. Billick's testimony was the cornerstone for all of this. And once that was pulled out, everything tumbles down.
Counsel, isn't it?
Go ahead, counsel.
I'm sorry. Isn't it that, look, they find an expert witness who's highly credentialed, defense counsel, and they make a tactical decision on prep that happens every day. And that explodes on a cross-examination, which is highly effective. And so when they get to the jury, they have to explain that, and you all may have explained it differently than this defense counsel did, but why is that ineffective as opposed to any other kind of tactical trial decision you make that doesn't work? You get an adversary who takes advantage of it.
No, I understand. So I think there's two responses to that. One, the way they thought to explain it in summation was affirmatively detrimental to the defense. This wasn't just a losing tactic. This turned into a liability.
Without the explanation, would this have been ineffective?
I think it would have been a closer call. With the explanation, it certainly became ineffective. And it really shows how this case stands in contrast to Pavone, where the summation comment was an explanation where the attorney was doubling down on the theory. He wasn't undermining it. He explained his reasoning. It wasn't that he didn't believe in this expert. That attorney still thought that the testimony or the information that he gave that expert was enough. The transcripts were enough. Here, these are defense attorneys who are telling the jury they don't have faith in the evaluation. If your attorneys don't have faith in your defense, why would a jury? And that is what makes this very detrimental to this client.
If it's not ineffective to, for example, call a doctor who testifies, you call the doctor, defendant hires the doctor to testify that the defendant didn't know what he did was wrong, and then the doctor testifies that the defendant did know that what he did was wrong, and we found that not to be an effective assistance of counsel. Why would we find this where the doctor hasn't really said, all he said is I didn't have this information, and it may not even have changed my diagnosis. So why would we find that ineffective?
Because you have defense counsel admitting to the jury that they think it may change his diagnosis. They don't have faith in it. They don't believe in it. And we can see the strategy laid out. There's no further inquiry.
I'm sorry, I still don't see the distinction. Defense counsel calls a doctor to testify one way. The doctor testifies in a way that completely destroys the defendant's defense, and we said that's not an effective assistance of counsel.
Well, you did in Bennett. And that is actually, so you have found in those situations counsel ineffective because they failed to prepare the defense. And that's what happened here. And the other thing that I think is critical is that.
Let me stop you there for a minute. I've had witnesses go south on me, and I'll argue it's on me. It's not my witness's fault. Blame me. I didn't prepare him or her correctly. I should have given him that piece of evidence. That's just good, well, mediocre lawyering. But that's what lawyers do. I mean, you know, as your opponent keeps saying, you got dealt a bad hand. As I read the record, this case was going south when the defendant testified. I mean, I don't want to say that was ineffective, but, you know, this seemed to me to be almost a sideshow after, you know, after what was presented to the jury at that point. So, you know, to then say because of the summation, it's wrong, I'm just missing it. If you're stuck, and it seemed to me they were stuck, and you finally get a doctor, you know, that you can put on, and you say, I've got 3 prongs to this, you know, with respect to his and you tell him that and ask him if he can testify to that, it seems to me you've done a pretty good job.
Well, there's a big difference between taking the hit, which I think the attorney in Pavone did, and saying to the jury, don't bother crediting this. And when, especially since that testimony, Billick's testimony, goes to the very core of the entire defense.
So just take a step back then. You're saying this is not a single error case?
No. It can't actually, we would argue that under either analysis, it would,
Okay, well then,
but we see this as a series of
I tend to see it as a
errors.
single error case. So tell me on how this qualifies under our jurisprudence under a single error case.
So Blake, when it describes an error that taints the entire representation, this was a critical component of the defense. And if
No,
Billick's
I thought that it talked about that the single error standard was that it was decisive, it was determinative.
It's
that-
dispositive.
It was
That's right.
dispositive, thank you. That's a little bit different from what you said.
Well, I mean, also you have a different ruling in Claremont where you actually found it not to be dispositive, but it certainly was a single error. So, I mean, in a sense, it needs to
Vermont was a completely different issue.
I understand, but it's also a question of whether it overshadows the entire representation. And here, where you have an attorney signaling to the jury that they do not credit, they do not believe in their own expert witness.
Where do you point in the summation for that point?
The statement, and also I submit that those photos would have changed possibly his evaluation. It's on page 915 to
That's saying
916.
whether he don't believe what he said?
But that's what the jury, I understand, that is overstating it. So the point
Well,
here is
well,
it's signaling to the jury.
Don't skate past that so quickly. I mean, that's kind of my point. I mean, didn't she say, you know, that he was not there to diagnose the complainant's injuries, that he was there to, you know, I mean, that's not throwing your expert under the bus.
If he had left it at that, I would agree with you, Your Honor, but she didn't leave it at that. She took the added step of saying it could change his evaluation.
But
and
he
that,
said that. The doctor said it might, but it might not.
He
And
was-
that's the evidence, right, what the expert said. And he said it might or it might not. And that's what they're arguing to the jury.
then they should never have guided him to those subjects on direct. They should have prepared him. The
But what's
cornerstone
what
of
is the devastating error there I'm trying to figure out? Yes, it's a bad cross, and you don't want your expert to ever have to say it might not. But then in the summation, they're dealing with that as best you can by saying it might not. And the testimony, which is the evidence, not the summation, is it might, but it might not. So the jury was free to believe his theory would have remained the same.
this cross was predictable. They guided him to those subjects.
It's always predictable after it happened.
Then he shouldn't have been put on the stand. There was ample evidence of a psychiatric defense here without him. This
So
was
how do you
a
do that? See,
15-year-old kid.
Now you're talking tactics, though, because if she hadn't put a shrink on the stand, you know, I assume you'd be here arguing, and they didn't even get an expert with respect to the psychology of this thing.
We couldn't do that without a 440, without them saying we had a reason for that. Here, the reason was problematic.
Losing tactics is, I guess, what you're confronted with here, right?
This is not a losing tactic. This was a grenade set to go off in the middle of trial. That's what distinguishes this from other types of cases.
Thank you, counsel.
Thank you so much.
Counsel?
I just wanted to address what my adversary said about that there was pretty much no doubt that these questions would be asked. What you have to realize on this record is that there was absolutely no indication what the prosecutor would get once he asked these questions. You know, there was no indication that the motive theory had been disclosed to the expert. No indication whether the expert had seen the photos of the medical records. In fact, it seemed as if the expert had seen the photos and the medical records because he gave an accurate description of the wound. So, you know, you got to ask yourself, is my adversary going to ask this question? Is he going to take the chance? Because if you don't know the answer to a question, it can basically just blow up in your face. So just because they went to these topics, it doesn't mean that the prosecutor would venture into this area and necessarily ask this experienced expert. And this wasn't his first time testifying, and he was a guy who really, really liked to talk. Are you
Going off the script here?
What's that?
Is he just
Sorry,
going
Judge?
off the script?
Did Dr. Billa go off the script?
Is that what he's doing, just going off the script?
Well, if you tell the courtroom about, that Queen Elizabeth has just knighted you, I mean, yeah, that's something he actually said when he went through his CV, and that may have been a little bit off the script. But, I think he impressed the jury with his knowledge. He was an impressive expert, and, I can't imagine a better expert for this case, and who actually offered them an opinion, which is what they needed to sell this defense. It's hard enough with an expert. How are you going to do it without one? By putting the defendant and his mom on the stand? Two of the most biased witnesses in the whole courtroom, or just having him take the stand and offer no opinion and just, go through a few general things. I mean, the prosecutor's going to hit that even harder on cross. So again, I just want to say again, as the court recognizes, they were dealt a bad hand, but they played it exceedingly well. I'm sorry, does Your Honor have a question?
No.
Oh, okay, I'm sorry. They were dealt a bad hand, they played that hand exceedingly well, and for that reason, the Second Department's decision should be reversed. Thank you.
Thank you, counsel.